On July 11, 2025, 39-year-old Eric Littleton stood before the 34th District Court in Romulus, Michigan, facing a trio of serious felony charges: first-degree criminal sexual conduct causing personal injury, third-degree criminal sexual conduct through force or coercion, and larceny in a building. During the arraignment, the court scheduled a preliminary examination for July 30, 2025, to be held before Judge Brian Oakley. As we've discussed in previous episodes of ATC, a preliminary examination in Michigan's district courts serves as a crucial checkpoint in felony cases. It's where the judge must decide whether probable cause exists to believe the defendant committed the alleged crime. If that threshold is met, the case is bound over to circuit court for trial. According to court documents, James Earl King Jr., supervising attorney with the Neighborhood Defender Service, was listed as Mr. Littleton's counsel of record, an organization dedicated to representing indigent defendants in Detroit. However, when the day of the hearing arrived on July 30th, it was staff attorney Sahar Farage who appeared in court, stepping in to represent Mr. Littleton during the preliminary examination before Judge Oakley.
All right, appearances for People versus Littleton.
Morning, Honorable Stephen Moore, on behalf of the people, 84724.
Good morning, Your Honor. Attorney Sahar Cross and Attorney Martin James Case, hearing on behalf of Mr. Littleton. Mr. Littleton, can you please introduce your record?
All right, ladies, we ready to go?
Yes, Judge, the people are ready to go, and I have a complaining witness who flew in from out of this country to be here today.
All right, put her on the stand.
Your Honor, I mean, Mr. Littleton, to refer the competency at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. He is not fully aware, Your Honor, when I try to ask him or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first time that it was a little off. If Your Honor was, I'm not sure if Your Honor was the judge at that time.
Was not.
Saying that I didn't think any.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you, it's a compounded issue, Your Honor. It wasn't just the first time; it was the second time also.
Denied. Denied. Twice I've asked you a direct question. You can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today. I didn't ask for an argument, counsel. I just told you my decision.
Going to be completely. I think to be ready and what to be Mr. Littleton had no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Understanding when there is a different matter that he's explaining to us is hard because I was going to come here anyway, and because Mr. Littleton was going to refer to competence.
No, he wasn't. No, he wasn't. You were going to ask for that.
The statute requires that the court at least consider the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear, and if Mr. Littleton and not assist rationally not comprehend what is actually happening, actually he cannot move forward. And I think the court has an obligation to consider.
During the hearing, Ms. Sahar Farage raised a serious concern before Judge Brian Oakley. She questioned Mr. Littleton's mental competency to stand trial. This issue is not merely procedural. It goes to the heart of constitutional fairness. For decades, U.S. courts have consistently held that putting a mentally incompetent defendant through criminal prosecution is unconstitutional. The standard for determining competency was first clearly defined in the landmark 1960 Supreme Court case, Dusky v. United States. Under Dusky, a defendant must have sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding and possess a rational, as well as factual understanding of the proceedings against him. 6 years later, in Pate v. Robinson 1966, the Supreme Court expanded on this principle, ruling that a court's failure to hold a competency hearing when there is evidence of incompetence violates due process. Michigan law mirrors these constitutional protections. Under Section 330.026 of the Michigan compiled laws, once a defendant's competency is called into question, the court is required to order a mental health examination. Then, under Section 330.028, a mental health professional must prepare and submit a report to the court addressing whether the defendant is competent, and, if not, whether there's a substantial likelihood that competency can be restored. Once the report is submitted, the court must hold a competency hearing to make a formal determination, because Ms. Farage raised a legitimate question regarding Mr. Littleton's competency. Judge Oakley could not move forward with the preliminary examination until that issue was resolved. In practical terms, this meant that the testimony of the out-of-country witness, who had flown in specifically for this hearing, could not be taken until Mr. Littleton's competency to stand trial had been formally determined.
Well,
Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Farage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. No.
Judge, I contacted Mr. King. I called NDS last week, contacted them specifically so that I could figure out ahead of the PCC who the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending him the digital discovery so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed that the next 4 to 6 Wednesdays were free in her schedule, and let him know that we would be flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport that she was sexually assaulted in, that if that happened and if she came here, we were holding this exam. Because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request or have him be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happened. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she was sexually assaulted in to her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he was not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through this hearing staying.
This is totally unconscionable.
The prosecutor informed Judge Oakley that she had made multiple attempts to contact Mr. James Earl King Jr. prior to the hearing, hoping to confirm whether he intended to raise the issue of Mr. Littleton's competency before she arranged for an international witness to fly in for the preliminary examination. However, she said, Mr. King never returned her calls. It wasn't until the morning of the hearing that she finally managed to reach him, at which point Mr. King admitted he had not spoken to his client at all. This revelation raised significant ethical concerns about Mr. King's conduct. Under Rule 1.1 of the Michigan Rules of Professional Conduct, attorneys are required to provide competent representation, meaning they must be adequately prepared and must not neglect legal matters entrusted to them. Furthermore, Rule 1.3 obligates lawyers to act with reasonable diligence and promptness in representing clients, ensuring that important proceedings are neither delayed nor jeopardized by inaction. Equally important, Rule 1.4 establishes a lawyer's duty to communicate, requiring that attorneys keep their clients informed and explain matters sufficiently the client can make informed decisions about their case. Given these professional standards, Mr. King's failure to meet with Mr. Littleton, his lack of communication, and his absence from a critical preliminary hearing could be viewed as clear lapses in his ethical responsibilities, potentially violating his duties of competence, diligence, and communication as defined by Michigan's legal ethics rules.